Hello. Thank you so much for coming out to this launch of Criminal on Precrime, Legal Studies in Canadian Punishment and Surveillance in Anticipation of Criminal Guilt. My name is Lauren Menzie. I had the opportunity to be involved on this project, and I'm really looking forward to sharing some of my work with you today. So I'm going to be briefly talking about how administrative legal processes take on a pre-criminal punitive nature, and how certain non-criminal legal systems have begun to bleed into or overlap with criminal systems, and similarly, how they mobilize punitive and precautionary responses to pre-criminal behavior. There are tons of examples of this in Canadian law, such as security certificates, extradition, non-conviction reports, civil forfeiture, and peace bonds. And the book provides a rationale for these processes, but there's also a fairly extensive analysis of provincial forfeiture legislation, as well as the use of peace bonds within a Canadian context. And this is the bulk of what I'm going to be talking about today. So these discussions are relatively contained within Chapter 4 of the book, which is titled Administering Criminal Law, Preventing Crime and Punishing the Pre-Criminal. The chapter posits that by prioritizing security, crime prevention, and precautionary approaches to governance, we've been able to justify or ignore quasi-criminal sanctions that are developed outside of criminal law. So here we have behavior that fundamentally seems to fit within a criminal legal process that's being addressed through other administrative forms of control. Now, why is this such a big deal? Well, we have non-criminal court systems, which are now seeing a growth of powers and the ability to govern morality in the same way that criminal courts have been doing historically. We have the ability to impose punitive measures and sanctions without affording individuals the procedural protections that are guaranteed in a criminal legal process. And by responding to behavior through peace bonds or forfeiture, the state has the same capacity to restrict and limit behavior after the fact, or to punish frequent violations of social norms, and only needs to justify this process through suspicion of criminal behavior. So, this chapter is concerned ultimately with how legislation justifies its own ability to presume offending and presume criminality outside of criminal law. By directing precautionary efforts towards property or towards a societal so-called reasonable fear that is directed at individuals, the state is expanding its capacity for governance, and it begins to police social insecurity without affording protections that are guaranteed under criminal law. Despite a different legal setting, the legislative foci are actually quite similar, and much of the language found in these cases invokes criminal law's aims to deter and punish. So I'd like to take a moment now to thank you for your interest in this project, and thank you for listening to a brief coverage of Chapter 4. And more generally, thank you for attending the launch at Robson Hall. I'm sorry I couldn't make it out, but I really appreciate the opportunity to tell you about my work. Thank you.